All right, let's talk about documents. And I want to think about documents in two ways. We have before and after. So, what I mean by that is when you are thinking about doing your basic estate planning documents, you're in the before stage. You have not yet done them. But then once you have done them, you are on the after stage. And let's start with the after. So, you've done your estate planning documents. Now, what? Please do not think now you're done. I really want you to think about now what. So, for example, healthcare proxy. Now what? You've done your healthcare proxy. Well, put one healthcare proxy in your glove compartment in your car. Next time you go to the doctor's office, you can say, I have my healthcare proxy in the car. I'm going to bring it into the office. Please make a copy or scan it into your system. Also, you can say, hey, I want to have a family meeting. I want to talk about this very important document and who's my agent name, who's my alternate agent name, and some thoughts that I have regarding it. Because I want you all to be on the same page in a time of need. And I know in a time of need, that is not the time to be wondering if I have a healthcare proxy, and if so, who is named? And thinking about thoughts as far as now what can take you to some very beneficial actions. So now let's think now what with the power of attorney. Now, we want to make sure that you've worked this through with your estate planning attorney as far as if you're having your agents sign after you as the principal have signed, or if you're having one agent sign but not the other, and so on. So that's part of now what, because if you left it that only you as the principal are signing, maybe now what means that your agent or your alternate agent is going to sign the document in front of a notary. And moving on from there, now what can mean who has an original of the document, who has a copy of the document, who has an attorney certified copy of the document. Do you even want to experiment a little with the document? Take it to your bank, have them put it on file. See if your agent can go in there and explain that they are now going to be acting as agent and want to do something in regard to the account. Do you want to even record the power of attorney with the clerk's office? So now what can mean a whole variety of things in regard to the power of attorney. And even if you have a trust in place, a power of attorney is always necessary because a power of attorney provides for legal authority in other ways that will fall outside of the trust or other legal arrangements. But again, going back to now what, there are a whole host of actions that can be taken after the power of attorney is in place. Now let's think about the will. You have your will. Now what? Well, first I want you to think, where are you going to be placing that original will for safekeeping? Is it in your home? Is it with surrogate's court? Is it with your nominated executor? And so on. And then I want you to think about any other wills that could be out there. This should have been part of the whole estate planning process, but your wheels can continue to turn and think, geez, did I forget about anything? Sometimes I have clients who think they did something so long ago that it doesn't even matter, that it's not really even effective, or they're doing another one now, so who cares about that one from the past? No, we want to know about any legal documents out there that could come to the surface and cause problems. So we want to be clear about what documents are out there and what we can do to get our hands on them and to make sure that the process is going to be as smooth as possible when it comes to be important. And as well, with the will, you can think about, if you do have a will in place, do you have, here in New York, self-proving affidavits along with the will? Some people may think they're all set to go with a will that was done, but those self-proving affidavits are not part of the will, and that can cause some problems going forward. So again, now what? Now what do we need to do if we're in the after where we have completed documents? And I will also say that sometimes you or your estate planning attorney will want to notify people that a document has been revoked, that they are no longer able to act under a certain document. And that kind of notification is extremely important. And that is part of the now what. You want people to be clear on their abilities to act on your behalf. And if they are no longer able to, or at least the document has now changed, that needs to be a part of follow through and the now what stage. Now let's go to the before, where you don't have these basic estate planning documents in place. So of course you're thinking of, what documents do I have out there? Because that needs to be a part of what you're going to do now, as far as some of the things I just said. And as well, you're thinking about any documents that can affect your planning. And so often we all forget what was done. What is on the deed? Even deeds alone, people forget, oh my goodness, the relationship is tenants in common. It's not joint tenants. Or, oh my goodness, we bought the property before we were married, and now we need to do something in regard to changing the relationship on the deed to establish, let's say, for husband and wife tenants by the entirety, and so on. So we want to try and, on the before stage, get our hands on those documents that are going to play a part in the planning going forward. So I just mentioned deeds. Of course, there's anything else at play, premarital agreements, postmarital agreements, divorce decrees, business interest. You have the governing documents. You have some of the other documents that will play a part in what you're going to do with the business interest and what can be done and maybe what should be done. Are you clear about what you own, percentage of ownership or member ownership or share ownership, partnership ownership, and so on. So I want you to think about before and after. Before, you're thinking about what documents you have already done and what you're going to do on reviewing and revising. And then you're also thinking of all those documents that play a part in what you want to do. Try and get your hands on them, establish what there is so that you're clear in your mind and can do what needs to be done going forward. By the way, this also is very important on all of the bank accounts, investment accounts, life insurance, retirement accounts, and so on, as far as beneficiary designations. So often people need to go back and remind themselves what there is. And that's always a part of planning. But then again, as I was saying, we have the after, where you have documents in place. And I want you to think of these two words, now what? Don't stop at just documents in place, because there's something that we can do on the now what that is going to be very helpful. All right, I hope this was helpful. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.